And we're back, Miss Kristi Valls. How are you?
I'm fine. How are you?
I'm good. You know, these days you almost have to say, if you're looking for an attorney, a lot of you do, call Kristi.
Thanks.
All right, you're welcome. We're going to talk about a few things that have, someone had called me and said there's been an article in the newspaper, it's been 3 years trying to pass this bill, but Alabama Supreme Court issues major divorce ruling on Friday, and basically, if you go through a divorce and you go through the child support and all of that, in Alabama the age is 19, correct?
That's correct. The age of majority in Alabama is 19.
19. Once the child turns 19, if you didn't already have it established in your paperwork that the other parent helps pay for college expenses, you had to hurry up and file prior to that child turning 19 to be able to possibly get those benefits.
That's right. You had to file a post-minority petition before the child turned the age of 19. The law had been that a case called Bayless was the case that actually established that there was post-minority support and that college expenses could be paid by the non-custodial parent. The judge had the discretion to determine what percentage that parent would pay.
And it makes a lot of sense because I know child support at that point stops. College kicks in unless there's special circumstances in your divorce decree. And a child has to, I don't know if the law has changed, but back when Jamies were going to college, you had to maintain a C average.
That's correct. You still do, and did. You still did, and you also had to show an aptitude for college. In other words, if you hadn't started college yet, you had to show you had the ability to succeed in college before. And then this Supreme Court case came down out of Athens, as a matter of fact. It was out of Limestone County. Christopher v. Christopher went up to the Supreme Court, and it was one in which mom was ordered to pay a percentage of college expenses under the Bayless ruling. And actually the Court of Civil Appeals found that that was still the case, that she still had to. It was appealed to the Supreme Court of Alabama, with an opinion written by Chief Justice Moore, struck down Bayless and said that that was not going to happen. It turned on a statutory construction of the law, basically said that the child custody statute, which says that a parent has the duty and obligation to support their child, they ruled that a child is under the age of 19, therefore no post-minority support. You know, there's always been talk about whether it violates equal protection clause to actually make a parent pay for college expenses when there's a child of divorce. When a child of marriage doesn't have the right to have the same college expenses paid for. But the court didn't decide the issue based on equal protection, because had they decided it based on equal protection, they would have gone back and every case that had been decided would have gone away. So what the court did was it did it under a statutory construction, which means that every case pending or from that point forward, no longer can college expenses be ordered. Anything that's already in place, anything that you agreed upon and is in your decree, is still good. It stays the same.
So if there are any parents out there that have a divorce decree and it does not even mention college support, they have to apply for that before that child turns 19, or there is no hope of getting it?
Well, there's no hope of getting it now at all in the state of Alabama.
So they can't go back and change it?
No. At this point, the courts have said no, that that no longer do they think that college expenses can be in the state of Alabama under the age of 19, that support is only going to be up to the age of 19.
Okay, well, let's talk. Very interesting, because that's, I'm sure, got a lot of people talking. And now every divorce that have children, this is going to impact them.
It will, and unless the parents agree that one parent is going to pay, the non-custodial parent is going to help with educational expenses, post-minority support, it's not going to happen.
Gotcha. Big news. All right, and let's talk about, there was another law on grandparents' rights, or let's say lack of.
You know, Alabama had been in the forefront, believe it or not, in grandparents' rights, in that I think we established one of the first statutes that allowed grandparents visitation rights in 1980. It was expanded throughout the years, expanded, until there was a case with the Supreme Court of the United States named Troxel that actually did away with grandparents' rights in the state of Washington. When it did that, it actually caused Alabama to amend its statute in 2003, started limiting how grandparents could visit until in 2011, grandparents' rights statute was struck down in the state of Alabama. And as of right now, there is no visitation rights
For grandparents.
for grandparents. Now, that's assuming the parents are fit. If you
Okay, so
can-
if there's still issues of neglect or child abuse, grandparents can take that to court to try to get custodial rights.
That's correct. If the parents are not fit, there is a mechanism by which, going through dependency court, that the grandparents could either have custody or visitation.
However, if you are just not getting along with your ex-daughter-in-law or son-in-law and they choose to not allow you to see the children, you can't fight that.
Right now, there's no statute in the state, no way to get into court.
All right. Very interesting. Thank you, Miss Kristi
You're
Valls.
welcome.
Well,
Thank you
it's
for
good to
having
see
me.
you.
I
You're
appreciate
welcome.
it.
Tell Robert hello.
I will.
All right, we're going to take a quick break. Stick with us. Jordan Flats here. We're going to talk a little sports. We'll be right back.